everyone present here today. Welcome to the demonstration Moot 2024. Presiding over today's round is a division bench comprising of our distinguished alumni, Mr. Agastya Sreenivasan and Mr. Neel Mehta. Mr. Sreenivasan is an associate at Solomon Cove, while Mr. Mehta was an associate at Cyril Amarchand Mangaldas. As avid mooters, they have judged several memorial rounds and oral rounds of prestigious moot court competitions. They have always supported mooting activities in GLC and have joined to judge moots as well as conduct workshops organized by us. Our mooters for today are Mr. Agastya Vijayraghavan, who is the counsel for the petitioner, and Mr. Karan Nair, who is the counsel for the respondent. They are both fourth-year students of the 5-year law course in GLC and are amongst the most brilliant mooters of our college. They have participated in various national and international moot court competitions such as the Philip C. Jessup International Law Moot Court Competition, the NLS Tri-Legal International Arbitration Moot, and the NLIU Justice R.K. Tanka Memorial International Arbitration Moot. They have secured podium positions in various intra-GLC moot court competitions and have also been a part of the Moot Court Association. I would now like to request our mooters to take their place on the stage. The demo moot being conducted today is for all our attendees to witness what moot court proceedings are like. In today's round, our two speakers will be arguing on behalf of either side of the moot proposition that has already been shared with you. We hope this will help you gain a simplistic understanding of how moots are, and we shall be elaborating and explaining this in detail in our orientation which will follow after the demo moot. With this, I'd like to request Mr. Agastya Vijayraghavan, our counsel for the petitioner, to begin with his submissions.
Please, my lords, I appear for the petitioner in the instant matter. If my lords are well versed with the facts of the matter.
No, I think it would be better if you give us a
Very well, lords. Lords, I am a student of a high school under the University of Haryana in the city of Brimalo. I was born a biological male. However, I discovered very early on in life that I am not a male at all, but rather a female. Lords, I felt thereafter that it is necessary for me to dress in accordance with the sex that I identified with. And to this regard, I approached my school principal in good faith so as to wear the uniform in accordance with my chosen sex. Lords, however, she promptly denied this request for reasons not known to me, and therefore I have filed this petition challenging this action on the part of the principal under Articles 14, 15, 19 and 21 of the Constitution. Lords, my submissions will be structured in a three-pronged manner. At the outset, I'll address your lordships with regards to Article 14 and 15 together. On the second prong, I'll address your lordships on Article 19 and thereafter on Article 21. Lords, with respect to Article 14 and 15, Article 14 talks about equality before law, and Article 15 talks about prohibition on the grounds of religion, sex, race, creed, etc., so on and so forth. Lords, Article 14 and 15, as your lordships would be aware, they form part of the scheme of the constitutional right to equality, and Article 15 merely constitutes an instance and application of Article 14. That being said, my lords, the crux of my submission is based on, with reference to this issue, is that the conduct of the principal is in direct violation of Article 14 and 15 on the ground that it arbitrarily classifies students into only two genders, whilst completely ignoring the recognized multitude of genders under Article 14. To this regard, I wish to take my lords to the judgment of our Supreme Court.
Counsel, before we move on to that, can you clarify for us if this school is an instrumentality of state against whom you can file a writ petition, firstly? Secondly, have you made the principal a party to this writ petition? Thirdly, are the actions of the principal attributable to the school?
It's just to answer your lordship's first question. If my lords would, the proposition in fact in that sense is not explicitly provided if this is a government school or not. But if your lordship would turn to para 2 of the fact sheet, it says that young high school student from One Direction Higher Secondary School, a prominent educational institution under the University of Haryana. So that is our primary contention, that this is part of a government university that addresses the first question of your lordship.
So you're assuming the fact that it's a government institution?
Yes, Milo, that's the fact. And in the present matter as well, here our main allegation is with respect to a breach of fundamental rights, which is why we've approached your lordships under 226. A writ would not necessarily be maintainable only against the public school. In any case of a breach of my...
So writs are maintainable against private parties as well?
Yes, Manoj. If there's a breach of fundamental rights, I can approach your lordships to issue a writ to that.
What kinds of writs are admissible against private parties?
Let's firstly, as in if you're asking me on the I can take your lordships through a couple
Do you have any judgment that says that writs are maintainable against private parties?
which at this moment I don't, but that I would assume is a settled matter of practice.
No, it's not a settled matter of practice. Otherwise, why would I, tomorrow if you have a contractual dispute, would you raise that dispute before a writ court?
Well, here there's a direct breach of my fundamental right, which is why
So if another person, if there is, let's say, wrongful confinement, wrongful imprisonment, there's a specific provision for that under our criminal laws. Why would you then file a writ? In what cases would you file a writ against a private party?
Well, in the case of habeas corpus, just to give your lordships an example, if I just, like since your lordships put a criminal case to my mind, if I tomorrow confine my mother to in a room in her house, and I tell her that you can't leave this room no matter what, then any other individual seeing this can file a writ before the Honorable High Court saying that produce this individual before the court.
Okay, but then if I as a private individual discriminate between, let's say I have a company, and when in my hiring practices I discriminate against a person, let's say basis their caste or basis their religion, can you tomorrow file a writ against the company, private company?
Yes, my lord, because it's in direct breach of your fundamental right. Under
No, please look at Article 15. It says the state shall not discriminate.
But I don't have an authority. I'm like fairly certain that there are a couple of authorities that have expanded this
You
scope.
must assist the court on this aspect. This is an important question of law.
Correct.
Continue.
No, it's with reference to, I was addressing your lordships with regards to Article 14 and 15. To this regard, I was going to take your lordships through a judgment that is National Legal Services Authority versus the Union of India. It's just to...
What are the facts of that case?
No, just with regards to the recruitment of people to the National Legal Services. So the National Legal Services Authority is a quasi-judicial body wherein they were recruiting people based on male and female, whereas transgender people who had mentioned their gender and the form as male, female and others were explicitly disqualified.
You see, already you can distinguish between your case and the present facts on hand. You are saying this is a quasi-judicial body, it's a statutory body established under a statute. Therefore, it becomes a state under Article 12, read with Article 15. However, in this present case, you are saying it's a private school or a public school at best. You have to satisfy us that it's an instrumentality of state under Article 12. Otherwise, how do we pass directions?
Also, under the cause title itself, we have made the state as well a party in this regard because it is part of the University of Haryana. If your lordships would see the cause title, Larry Smiles versus the state of Haryana.
So, what directions are you then seeking against the state?
No, firstly, we want our prayer is for issuing a writ of mandamus so as to set aside this action on the part of the principal and let me wear the uniform in accordance with my identified sexual identity. This prayer is very simple.
So then, just explain to me, because I see only one respondent, state of Haryana.
Correct.
There is no other respondent. The principal is not a respondent, the school is not a respondent. So how do you propose, you have filed a petition, how do you propose to overcome this difficulty? Because what is the direction that we pass at the end of the day against the state? State is not discriminated against you.
Well, our submission is that this school forms a part of the state because it forms a part of the University of Haryana.
So has the University of Haryana been impleaded as a respondent?
No, that fact sheet is on silent on that.
Okay. So, but then what is the direction you seek against the state of Haryana? Is the impugned action done by the state of Haryana?
Well, what we are saying is that the principal forms a part of the arm of the state of Haryana.
So you have to satisfy us on that point.
Exactly. And again, at this time, the facts are not exactly in my favor, explaining as to this with regards to the state, the proportion of the state with respect to the university. if that's all I can have at this moment. If I can address your lordships with regards to the specific violation itself. Lords, on Article 14 and 15, if my lords would turn to, basically, my lords, my submission is that like I mentioned, the judgment of Nalsa versus the Union of India, if your lordships, I will just read out para 13 of the judgment. I don't believe a copy is with your lordship, but I'll still read it out for your lordship's reference. Transgender is generally described as an umbrella term for persons whose gender identity, gender expression or behavior does not conform to their biological sex. Transgenders may also take in persons who do not identify with their sex assigned at birth. Further, there are persons who like to cross-dress in clothing of the opposite gender, that is transvestites, if my lords would note this. Resultantly, the term transgender in contemporary usage has become an umbrella term that is used to describe a wide range of identities and experiences, including but not limited to pre-operative, post-operative, and non-operative transsexual people who strongly identify with the gender opposite to their biological sex, that is male and female. Note, my submission to this regard is, transgender has been described as an umbrella term for persons whose gender identity, gender expression, or behavior does not conform with that of their biological sex. That is the first prong. Second part, the Supreme Court is very prudent to note that the Supreme Court has explicitly classified
You may take a wait.
You may take 2 minutes extra time.
I'll just summarize this submission really quickly, and then if there's time left, I'll address your lordships further. With reference to Article 14, like the definition of transvestite essentially means that a biological male or any individual for that matter may choose to wear the clothing of the opposite gender, opposite sex, and call herself or himself and identify himself or herself in accordance with that sex. What's that? And with reference now, I'll take your lordships back to Articles 14 and 15. Article 14 has used the expression person. Article 15 has used the expression citizen. If your lordships would like me to read out the article really quickly. The state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. And same lies on Article 15, the word citizen and the word sex is used. All these expressions, my lord, point towards gender neutral. These are all gender neutral expressions in that sense. Now, if we read this along with Nalsa, it becomes abundantly clear that Article 14 and 15 is not confined explicitly to males and females in that sense. And since the Supreme Court has expanded the definition of transgender, that would also form part of Article 14 and 15. That means I would have a protection under the same.
Council, what are the rules applicable, rules or laws applicable to the schools in the state?
My lord, in this matter, it will be like yes, my lord, I'll just read. The Karnataka Education Act of 1983 is like the reference, the pari-materia provision over here.
So Rule 11 of that mandates that every educational institution may specify its own set of uniforms.
Correct, my lord. And my question is not, I am not disputing the fact that the school has imposed a uniform or prescribed a mandatory uniform. My whole challenge is this, that I was born as a biological male. I believe that now that I identify as a biological female, and I want to dress in accordance with the same uniform that has been issued by the school itself.
But also for Article 14 and 15, there's two-pronged reasonableness, 2 minutes, which is basically rational, intelligible differential and rational nexus. So in this case, it could be a position that the school is not being discriminatory against you as a student individually, but as a class of all students, they're having set practices to make sure that the only purpose of education is being fulfilled as mentioned in the fact sheet.
But at the outset, the burden upon satisfying your lordships with regards to the rational nexus upon my learned friend at the outset. Secondly, my lords, I am not here on with respect to the. I am not disputing for a fact that that I am here achieving here for the purpose of education, etc. My main grievance here is this, that if I as an individual identify as a certain gender, and if the Supreme Court has laid down that I am also entitled to the same treatment as any other gender under Article 14 and 15, who is the principal to distinguish on those grounds? If my
I don't think in terms of Article 14 and 15, there is a restriction on the petitioner's right of self-expression. But the question that is before us is whether this right of self-expression can be before an educational institution, or whether the educational institution under the constitution can frame rules.
Since your lordships.
You have to show us how your petitioner has a right of self-expression within the confines of an educational institution, and why the rules are unconstitutional, illegal or arbitrary.
So I take your lordships through, that will bring me to my submissions on Article 19. I see that my time is slightly, but sure. Lords, under Article 19(1)(a), all citizens are guaranteed the right to freedom of speech and expression, and 19(2), since my lordship had put forth with regards to reasonable restrictions. Reasonable restrictions can be imposed on the exercise of this right for certain purposes. Lords, the petitioner has the right to his own identity and express his or her true self by dressing in a manner harmonious with his identity, and I satisfy your lordships on that. With regards to the reasonable restrictions on fundamental rights, I would rely on Model Dental College versus the state of Madhya Pradesh, which is a Supreme Court judgment full bench, which states that reasonableness has to be determined having regard to the nature of the rights alleged to be infringed, the purpose of the restriction, extent of the restriction, and other relevant factors. The court has to try to strike a balance between the fundamental rights and the larger interests of the society. Lords, here, just to move further, I take your lordships through one more judgment, that is of K.S. Puttaswamy versus the Union of India, 2017, 11 judgments, your lordships would be aware. The court held in that case that under Article 19, an individual is entitled to decide upon his or her preferences. Read in conjunction with Article 21, this liberty enables the individual to have a choice of preferences on various facets of life, including on what, how one will eat, the way one will dress, the faith one will espouse, and a myriad of other matters. In fact, my lords, para 323 of K.S. Puttaswamy explicitly includes the right to my sexual orientation also being included under my right to expression, if that answers your lordship's question, under Article 19. If I may read further, my lord.
But Modern Dental College also states that rights under Article 19(1) are not absolute and subject to reasonable restrictions under Article 19(2) in the larger interest and welfare of student community.
Correct.
In this case, the interest of student community is to promote learning, and that's the primary focus of the school. So then, why won't the reasonable restrictions be applicable in this case as well? Which is to not allow the student to dress in the outfit required for the female students.
Not my answer to that would be two pronged. Point number one would be that this would constitute the action on the part of the principal is a blanket ban on my right. I have established that I have a right to expression to begin with. It constitutes a blanket ban on the same. And regardless, even if we move ahead from that, there is no prejudice being caused to the other students in this situation. There is the public.
I'm not sure we're aware of that because no other students are party to this case. They could have similar issues or some other issue at point, but we can't assume that there's no prejudice against other students based on the uniform policy.
Because here, that would open that would require a separate plethora petition on a separate date as well.
Correct, but there could also be issues other students are facing, but they're okay with complying with the uniform policy of the school. Right, so I don't think we can assume that it could go either way, the assumption which you're making.
With utmost respect, if I go ahead and if I am accepting a discrimination or an illegal action or something that is malified on the part of the state, that cannot be held against me, or if I am filing a petition in that regard, I am talking about the breach that has happened just to me.
Correct, exactly, so that's what I'm saying. So let's stick with the remedies which we can provide to you as a petitioner approaching this court, and let's not make any assumptions against what other students may or may not face, without being aware of it.
The question that fell from your lordships was that what prejudice, there is a prejudice that might be caused to other students and therefore a reasonable restriction could be put in place. My answer to that question is that prejudice needs to be established to begin with, which my learned friend has failed to do. In fact, at the outset, even if we go to the Moot proposition, if your lordships would refer to paragraph 13, the last line, he approached the principal of ODHS with a request to allow him to wear the uniform prescribed for female students in good faith. And thereafter, in paragraph 14, the first time, the request was promptly denied on the ground that the college regulations mandated the uniform, so on and so forth. So there is no sorry.
Correct.
So if you read the full sentence, the college regulations, promptly denied on the ground that the college regulations mandated the uniform as prescribed for males and females to promote harmony and a spirit of common brotherhood transcending diversities. Correct. And they've also mentioned in, I think, the start of the fact sheet, which says that the primary purpose of enforcing the uniform policy was to have the primary focus of education.
The
Keep
logic
in
is
mind.
right. I'm not challenging this policy to begin with. That's what I'm trying to put forth before your lordships is that at this point in time, the school is recognizing merely two genders, female and male, based on sexual orientation. What my submission is now whether or not other genders should be included, whether or not there should be a separate uniform, that is something like your lordship said, we cannot assume what the other students would want. My prayer to this regard is, if I believe that I fall under the bracket, there are two buckets that the state has put forth here with regards to uniform. I believe that I fall in one bucket instead of the other. How would that cause prejudice to anybody at the outset, firstly? And secondly, how is that beyond the scope of the petition that has been filed over here before your lordship?
Anything else that you'd like to submit?
No, it's that brings an end to my submission. My prayer was with regards to your lordships are aware, is to issue a writ of mandamus so as to set aside the action taken by the respondent and permit me to
Set aside what action?
Since the principal has explicitly denied my request to wear the uniform in accordance with my sexual identity. My prayer to that regard would be to reverse this.
Okay. Good. Thank you.
Sorry, does the bench have the power to set aside his action and direct the principal to not enforce the policies?
Under 226, my lords, if your lordships are satisfied that there is a breach of fundamental rights, your lordships can issue a writ to that.
Understood, thank you.
Lords, I appear for the respondent in this matter. Before I proceed on a very primary level, your lordships has brought out the point on maintainability. As my learned friend stated, the question of whether the petition is maintainable and whether the actions of the state, whether the actions of the school, in fact, are susceptible to the jurisdiction of this court is a question that needs to be answered by this court. The first thing that this court must look at is under Article 12, as your lordships has pointed out. The instrumentality of a state has to be determined with a range of factors. Amongst them would be whether the organization or the school is receiving funding from the state, whether the state exercises control over the institution. I sense a hesitation, Lordship.
Counsel, but the only respondent in this case is the state of Haryana.
Indeed.
So the question of instrumentality of state, would it arise even considering the fact that there is only one respondent?
Indeed.
And that is a state, that's not even an instrumentality, that is the state.
Indeed. Our first submission would be the petition must, in order to have any release against the school or the principal must have been made a party to the petition. Even if we concede to that point, the maintainability of the petition is also under question insofar as the school is not an instrumentality of a state, or that's a question that needs to be answered.
So are the school, the principal, the university, are they necessary parties, are they proper parties? Is the concept of necessary and proper parties of CPC, can that be imported in a constitutional matter? Or can we exercise our inherent rights of the High Court?
Indeed. Lords, in 226 jurisdiction, this court may in fact exercise inherent powers, and the concept of necessary parties under CPC is not per se applicable here. However, we still, it is our submission that for any relief to be granted against the school or the principal, the school or the principal must be heard basis the principle of body alternate partum. Since that is not present in this petition, the petition on this first primary principle must be dismissed. Even if we concede to that point, we also submit that the school is not an instrumentality of a state, or at least that is a question that needs to be answered by considering the factors, the range of influence that I sense a concern.
So what is your position? Are you stating that the school does not fall under the provisions and entitles it to be categorized as a state?
Indeed. My first primary submission is that the school does not fall within the ambit of state under Article 12. However, even if this court decides...
What are the factors that determine whether an organization is an instrumentality of state?
Indeed.
Do you have any judgments to support your answer?
Indeed. In BCCI, in the judgment of BCCI, the Supreme Court has considered this, and they have laid down a couple of factors, inter alia, a few of them being, as I mentioned, that whether the state or the central government or the state government exercises any influence in the decision making of the institution, or whether it is providing any financial assistance to the institution, because these would materially affect the decisions taken by the institution. In this case, the facts per se are silent. Even if this court were to assume that this writ petition can be against the school, we still have submissions on that regard. If your lordships would like me to proceed to those submissions, and go on. Indeed, my lords. My lords, another thing that I'd like to point out is that the challenge in this writ petition, as far as I understand my learned friend's case, is to the decision of the college. It is not to the basis upon which the decision was arrived at. It is not to the Education Act of the state of Haryana. It is not to the education rules of the state of Haryana. It is not to the manner in which the decision was made. It is
understood. So then, why is this action not arbitrary? What are your reasons?
Indeed.
You must be aware that in Sharavano versus Union of India,
Indeed.
Justice Nariman laid down the concept of manifest arbitrariness, which is that if you arrive at a decision without an application of mind, without giving reasons, that is manifestly arbitrary.
Indeed.
Why is the decision of the principal not manifestly arbitrary?
Indeed. I'd like to address that question in 2 points. The first is the facts as they stand say that the principal promptly responded. We would not go so far as to assume that there was no consideration on the principal's part. But to the extent that the question of arbitrariness stands before this court, there are 2 principles that this court must rely on, and the test consists of 2 main elements. The first is whether any classification that is sought to be achieved is a reasonable classification, and the second is whether there's a rational nexus or a rational relation to the objects sought by that particular action.
No, that's what it's what you're talking about is the concept of arbitrariness as developed in Anwar Ali Sarkar and all that.
Indeed.
In 2014, when striking down triple talaq, Justice Nariman's judgment went one step forward and developed the concept of manifest arbitrariness. That is, you don't even need to get into rational nexus, intelligible differentia, or any of these. If it is unreasoned, it is arbitrary, or if it shocks the conscience of the court, it is arbitrary, and manifestly so, like on the face of it.
Indeed.
So why is this not on the face of it arbitrary? What is the reason? What are the reasons provided by the principal?
Now, your lordships may consider on a very fundamental point that this distinction and this decision is based on a policy that the school follows of equality and of uniformity, and that ties into the discipline of the school. The decision of the principal and the decision of the school is basis that the students must conform to the uniforms prescribed, and that emanates from the state of Haryana's education rules under Rule 11. So even if your lordships were considering the question of manifest arbitrariness, my humble submission is it would not pass that test, and my lordships would not consider that.
How do you deal with the recent same-sex marriage case, Supriyo Chakrabarti versus Union of India, where when considering the definition of a male, it said including, so it's not just cisgendered males, but also transgenders who identify as a male are considered male for the purposes of marriage and for the purposes of social union, and vice versa, as to who are considered females. In the present case, if the petitioner considers themselves to be a female, then according to this judgment, if they were an adult, they would have the right of social union as well as of marriage under those guidelines.
Absolutely.
So if based on that judgment, why can't the petitioner identify as female and wear the uniform prescribed for females?
Because my submission to that is even the Supriyo judgment and even the Nalsa judgment, as my learned friend has cited, they deal with an identity of the individual. These are questions of whether the individual has the right to exercise the identity. My submission is absolutely the liberty of the individual, the identity of the individual is not under question here. But that identity must not go so far as to expression which is beyond the regulations stipulated by the school.
Because the regulations stipulate that you cannot identify one way or the other.
I may clarify, that's not what I intended to say. But also the regulations state that there is a uniform prescribed for male students and female students. That right?
So if tomorrow a petitioner identifies as female, they wear a female uniform. If they identify as male, they wear a male uniform.
Indeed.
How are you concerned, and why is the principal worried that the uniform, it's a prescribed uniform, you're wearing the prescribed uniform. You're not creating a third uniform and wearing that.
Indeed.
So uniformity is still maintained. The larger objective is still maintained.
Indeed. If my lords would look at the facts, due to certain instances that have been happening all over the nation, the petitioner had this emotion, or that the emotion that was suppressed for a.
Which para number of the fact sheet?
We'll also look at paragraph 11 onwards, 11 and 12. If your lordships are with me. Indeed. This pertains to a separate case that was happening, that was occurring throughout the country, wherein the petitioner was closely following the facts of this case, and the petitioner feels so that the petitioner had suppressed their identity for a longer time, and they wanted to express their identity. We have no qualms with that. There is no concern with that. However, that expression cannot go beyond the rules and regulations stipulated by the school. And my lords, that brings me to what kind of prejudice is caused. Indeed, I sense a concern.
But it's not going beyond the rules and regulations set by the school, right? From what the fact sheet is mentioning, the petitioner is not asking to dress differently. He is just asking to be allowed to wear the uniform prescribed to female students instead of male students. He's not asking to he's not asking to deviate from the existing uniform which is being prescribed to female students or dress something completely different. He just wants to use the uniform, but the ones which are prescribed for female students. So how is that deviating?
Your lordships are right on that point. The difficulty here is that we have no basis or we have no standards to determine at what change or what is the metric for this change in an individual's identity. If there was, yes.
But I don't think the school is in a position to decide on what basis do we decide when there's a change in the person's identity. It's a person's choice on how he wishes to identify and what gender he wishes to identify as.
Your lordships are absolutely right, but that consideration would have to be made on a greater policy level. That cannot be made by the school, only the school, because that would stem from the state government. That would then trickle down to the policy levels and then be adopted by the school. Because this overall pertains to something that is happening all over the country, and a change that has to be affected all over the country. Right now, the petitioner's case is a very limited point. If this policy decision has to be considered, all stakeholders who have a say in this will have to be considered by this court.
Let us take an extreme position and analyze your contention versus the petitioner's contention. Let us say all the boys in that particular school decide to identify as female. They wear female uniforms as prescribed under the guidelines. Everybody is wearing the same uniform. The school's purpose of uniformity is maintained. There is no harm. Similarly, all the females in the school identify as male and wear the male uniform. Everybody is wearing the same uniform. So why is the state concerned about this?
Indeed. Lords, the question of identifying as one particular individual or one particular gender is not so simple as how the petitioner makes it. The question involves a lot of depth, because if the school stipulates two particular regulations, any change from that will have to be considered on a very large policy level. I mean, just illustrate this by highlighting for lordships a prejudice that may be caused to all the other students by just the petitioner's actions. If this is not considered, the petitioner is a biological male born at birth. The petitioner identifies as a female. Is this court taking into account the difficulties faced by other females in the school? Because if a petitioner who is a biological male may dress as a female, the petitioner would also have to use the the female washrooms. The petitioner would also have to be privy to the female to access to facilities which are only restricted to females. So my humble submission is, as long as there is not a clear policy terms.
As on today,
Indeed.
the petition that is before us
Indeed.
does not seek any of those reliefs.
Indeed.
Today we are just on the scope of uniform, or nothing else, not about access to public spaces.
Manoj, that's exactly my point. The petition is so limited in its scope that any decision by this court will have a triggering effect on all these.
We'll state in our order that this is limited only to the issue of uniform.
Indeed.
And the petitioner may come subsequently for other issues, and that may be decided on their own merits.
Indeed, Manoj. Because my submission to that would be, even if this court were to consider the prescription of uniform, the prerogative of the college of ODHSS to prescribe a uniform does pass the constitutional muster under Article 14, 19 and 21, and that is a binary submission. Even if the question of whether the petitioner wants to dress themselves as a female is established, the prerogative of this college.
What are the tests under 19.2 that show that the restrictions you are imposing are reasonable?
Indian laws. Laws for any restriction to pass constitutional muster, that restriction must be a reasonable restriction, and that must fall under the 8 grounds under 19.2. One of them being, and the ground that we rely our restriction on, would be the ground relating to public morality and decency. And as your lordships are aware, this definition of decency and morality is not defined anywhere. This is an ever-evolving concept.
Okay, so then how about the proportionality standard? How do you use that in this case?
Indeed, Manoj. Manoj, the proportionality standard is completely satisfied because if your lordships would look at this not as a...
First, explain what the proportionality standard is, all the 4 prongs of the proportionality standard, and show us from the facts how they are satisfied in this case.
Indeed, Manoj. Manoj, I may not be able to assist you with exactly all 4 prongs because I'm not absolutely aware of that and I'm not relying on that for my submission.
First prong is whether the rules that are there are legitimate. Second is that there is a rational nexus between the rules frame and the objects sought to be achieved.
Indeed.
Third is the necessity prong. Is this necessary for you to reject the petitioner's wearing a female uniform? Fourth, is your proposed action of refusing this request, does this conform to the least restrictive method of restricting her fundamental rights?
Indeed.
Are these satisfying, these 4? Is your proposed action the least restrictive method? Is it necessary? Can you satisfy us on those points?
Indeed, Manoj. Manoj, let's look at the first point on whether this action is legitimate. Manoj, this action and the legal backing of this action stems from the State of Haryana's Education Act. The State of Haryana's Education Act and the under made rules, which are the 1995 rules, prescribe under Rule 11 that any institution may stipulate or prescribe a uniform. So that the legal basis for this action is satisfied on that point, for it being a legitimate action. The second point that we have is whether there is a rational nexus to the objects sought to be achieved. The objects sought to be achieved is to create uniformity and to create some sort of equality amongst all students. And this is not some specific concept only in this school. This is something that is acknowledged all over the world, that there has to be a sense of uniformity, and as the word suggests, uniform, there's a sense of uniformity among the students, and there should not be any distinctions. Coming to the third test, the lordships will look at necessity. Let's look at what this restriction is, and my lords will look at this not as a restriction but a regulation. The school is merely seeking to regulate the conduct of its students within the school hours. The expression of the individual is not under question here. The individual is free to express themselves in their daily lives. However, when they enter into a school, they consent to the norms prescribed by the school. And when they consent to the norms prescribed by the school, they have to abide by whatever is prescribed for the entire student.
So Article 19 just says all citizens shall have the right to freedom of speech and expressions. As far as I understand this, I don't think there's any restriction. It's 24/7, 365 days a year. So even if your argument is okay, you're restricting their right or you're curbing the right to express themselves for the few hours that they are in school, that still violates their right to some extent of expression, right? Because that's, let's say, 4 hours every day into 5 days a week into 52 weeks. You're still curbing the right of expression to that extent, so I don't think that's a valid argument.
But also, if my lordship will look at it in a different way. As the lordship pointed out, this Article 19 right is not an absolute right. The right is susceptible to reasonable restrictions imposed by the state or the school. Now, those reasonable restrictions to have effect must stand the constitutional muster under the proportionality test or the other tests laid thereunder, including the prongs under 19.2. My submission is, if this action is satisfying all these tests and the prongs, then this action is a legitimate action. And therefore, the question of it being a restriction does not, the restriction being unconstitutional does not arise in the first place. If your lordships are satisfied with that, I would just like to leave your lordships with one illustration. My lords, let's take an instance where there is a religious institution. For entry into the religious institution, there are certain norms prescribed. For example, a person or an individual may have to cover their head. A person or an individual may have to leave their footwear outside. These are not places where the absolute right of where the right of the individual is absolute. They have to conform with the individual.
The reason for that is Article 25 and 26.
Absolutely.
Is there a similar constitutional provision protecting educational institutions?
Indeed. The provision would be the right to education under Article 21A, but that would not. Indeed.
That's not applicable to us, because that's only 14 years, and where right now it's higher secondary, which is I think 11, 12 standard, which is way higher than 14 years of age.
My lords are right. I was just illustrating your lordships that there are instances in which an institution may prescribe certain regulations, and for an individual to be a part of that, of that institution, the individual has to satisfy or has to conform with those regulations, as long as the regulations are constitutionally valid. And my primary submission, my submission is that these restrictions are constitutionally valid under the under these tests of 14, 15, 19, and 21. But this is the end of my submission. If your lordships have any other queries that I'd like to any minutes.
Counsel, before we begin, there is one question that we had. Is that you seem to be a high school student. That is, you don't seem to be a major. No, but higher secondary, are you a major or a minor?
The higher secondary, in my most respectful submission, would be a major.
But 11th, 12th standard generally is considered. Okay, assuming you are a minor, would you require a guardian to file a petition on your behalf, or can you file a petition yourself?
Yes, my lord, I require a guardian to file it on my behalf.
Assuming you are a minor. Okay. Do you have any judgments?
It's at this moment in
Oh,
time.
no problem.
It's just to address, I don't know major points for rebuttal, but just to address your lordships, and since my learned friend and your lordships, the question that fell from the court was that we should include all the necessary and proper parties and everybody should be given a proper hearing. To that regard, with my lord's permission, we can claim leave to amend the petition and include the proper necessary parties under Order 6 Rule 17. Can file an IA to that regard, tender a draft amendment, whatever your lordships.
Is Order 6 Rule 17 applicable in the present case or to writ petitions?
Yes, my lord.
That's a CPC is applicable to writ petitions?
No, my lord, but Order 6 Rule 17, I'm not, I think it's been, I believe the judgment is Naresh Kumar Megachkar versus the Union of India. That includes the scope with reference to amendment of pleadings, wherein the matter was with regards to tendering an IA, where a person wanted
Narish
to.
Kumar Virajkar of the Bombay High Court or Supreme Court?
Supreme Court.
You're talking about the 9th judge bench.
No, no, it's a 5 judgment. It's a separate. I don't have the exact citation on hand, but that's to the best of my knowledge.
What did that say?
Because in that provision, it brought in in that particular instance, it was an old judgment, I believe, in the 60s or something. And the provision, the question that arose before the Honorable Court was that whether Order 6 Rule 17 would be applicable in the case of amendment for impleading proper and necessary parties. Which, my lord, would be the case over here, since your lordships, the question has fallen with regards to giving everybody a proper hearing. That is why no major points for rebuttal, just a suggestion if your lordships would give. I'm okay. If my lord has any question.
Do you want to transfer sole rebuttal?
As far as standard practice goes, the sir rejoinder is only to the extent of the rejoinder. So I'd like to make one short point. Even if we were to take my other friend's case at its best, saying that Naresh Mirajkar applies to Order 6 Rule 17, and then the amendment can be carried out. The amendment is a very limited aspect. The question here is on impediment, and impediment is not covered in that judgment. So therefore, for any relief to be granted, there must be an impediment of the parties. Amendment refers to a particular part of the petition of the pleading. That's all.
Thank you.
I would like to express my heartfelt gratitude to Mr. Sreenivasan and Mr. Mehta for sparing the valuable time for judging the Demo Moot 2024. We indeed look forward to hosting you in the future, sir. If you could give a collective feedback to our audience.
Okay, I don't know, generally feedback is given to the participants, so I don't know how to give a corrective feedback to the audience. Just, I would say that, these are your seniors, take a cue from them in how you prepare, read your fact sheet very thoroughly, come prepared, have a copy of the constitution, if it's a constitutional problem, on hand. If it's filed, let's say, before the Bombay High Court, then look at the Bombay High Court rules and keep that also ready. Be fairly familiar with certain procedural questions. Who are the parties involved? Whether they are a state, whether they are a private party. Incidentally, I asked a question to the learned counsel for the petitioner. Can you enforce fundamental rights against private parties? And he said yes, but he did not have a citation with him. The answer to that is a 2021 judgment called Kaushal Kishore versus State of UP. So keep those ready on hand. Keep your research ready and try and anticipate what questions will come from the bench. Because if you anticipate the questions coming from the bench, then you can prepare for it and you'll have answers ready. Different people have different styles, so either keep a speech ready for yourself or keep pointers ready. But be aware that as judges, we might take you, especially if there are like 4 contentions, we might first ask you to do contention 1, then contention 3, and we'll make you jumble around. And we might try and throw you off. We might try and ask you questions that may confuse you, that may put you off track. And it's your job to not lose focus and come back. So just keep at that, and at the end of the day, it's just a matter of practice. So the more you do moots, the more you practice, the more it will help. Yeah, that's all from my side.
So I think Agastya has covered a lot of the points which I have to speak on. The first thing is, if you all want to Moot, again, this was just a demo Moot, so we were being more lenient, we were not jumbling it around. As Agastya mentioned, we were not asking and moving around from different contentions because we wanted to make sure you all also get an understanding of what they're trying to argue and there's a continuity to the arguments. That may not actually be the case in the Moot you're preparing for. The second thing I would like to say is, again, it's work. Like, it takes a lot of work to find the case laws, see how it applies to your fact sheet, how it applies to your situation. You need to tie it all together. So it is work, but it does work out in the wells. Second thing is, again, GLC is known for the alumni, the seniors. You all should, if you all are doing any moot, you all should always reach out to some senior who's mooted. I think we take part in most major moots, so you should try to see if you can get connected through MCA to any of the ex-participants of that specific moot, because then they are the best people to guide you to that moot based on their experience of how did they go about it, what helped them, what did not help them, stuff like that. So just keep that in mind when you all are helping, because you never know how far that help will go. Now coming to the actual moot part of it, the one major thing is know your fact sheet well. You may plead ignorance on your case laws at times. That's okay. If you don't know something, if the judge is asking you something which you're not aware of, you can plead ignorance. You cannot plead ignorance on a fact sheet. That's an absolute crime to commit. You cannot say I don't know, or oh, I'm not sure, or say something especially contradictory to your fact sheet. You can't say X things and Y is there. For example, I think we were really pressing both the councils on the fact that whether it's a public school or a private school, and none of them mentioned, but if you see point number 9 says, on the other hand, the school maintained that as a public educational institution, it aimed to create an environment of learning devoid. They could have easily referred to this point and clarified that it's a public institution. So that's something very important. Make sure you know your fact sheet well, because I'm sure the judges will know it very well, and they know it spick and span in and out. Like in one reading, they will know it very well. So please make sure you know this well. As Agastya also mentioned, do a thorough research on the procedures which are required based on the provisions and sections of the law that you're approaching the court for. Another thing to keep in mind is just small things. Like example is, if we're asking you a question, you give a response, then you should clarify and ask saying, oh, is that okay? Should I move on? Can I proceed further? Do you require any further clarifications? It's just like subtle, small points to keep in mind, but that goes a long way just to make sure that the judge is satisfied in whatever you're trying to say and the point you're trying to convey is received by him. I think that's more or less it from my end. Thank you.
Thank you so much, sir. I would also like to thank Mr. Karan Nair and Mr. Agastya Vijayraghavan for participating in the demo Moot 2024 as speakers. We thank you for always being unwavering pillars of support for us. Thank you so much. Over to you, Disha.
Thank you, Tanisha. The demonstration Moot is now over. We would request the audience to kindly remain seated as we escort the judges. The orientation shall begin shortly.